Rights of accused persons. The protection of the accused is universally considered to be in the interest of all civilized systems of law. All legal frameworks establish standards for the rights of the accused to guarantee that criminal proceedings do not unjustly harm the alleged offender, and that their right to a fair trial is assured. These foundational ideas, developed within human rights law, have been adopted globally on both national and international levels. These rights exist not merely to protect the individual, but to promote a responsible liberty for society as a whole, serving as a vital protection against arbitrary power or unwarranted government interference. An important measure of a society's civilization is the extent to which human rights are respected and protected within the context of criminal proceedings. Key international instruments establishing these rights include the Universal Declaration of Human Rights, UDHR, and especially the International Covenant on Civil and Political Rights, ICCPR, alongside regional instruments like the European Convention on Human Rights, ECHR, and the American Convention on Human Rights, ACHR. The individual's interaction with the justice system begins with potential detention, a critical stage where protections are essential to prevent abuse. The physical freedom of a person is paramount, and state authority to arrest, search, question, and detain must be clearly stipulated and exercised only when absolutely necessary. A fundamental protection is the right to be informed promptly of the reasons and grounds for arrest. The individual must be informed as soon as possible, in a language they understand, of the nature and cause of the charge. If the reason for arrest is withheld, the detention may amount to false imprisonment until the individual is informed. Crucial protections during arrest and interrogation involve the right to silence and privilege against self-incrimination. This right dictates that no person may be compelled to testify against himself or herself or to confess guilt. Under international human rights law, this privilege is interpreted as protecting against the absence of any direct or indirect physical or psychological pressure from investigating authorities to obtain a confession. Methods of compulsion are deemed wholly unacceptable, and the accused is protected from coercion, duress, threat, torture, or any cruel, inhuman, or degrading treatment or punishment. Furthermore, no negative inferences may be derived from a person's failure to testify or confess guilt. The right to counsel must be respected from the moment of arrest and at all stages of the criminal proceedings, including during interrogation and pretrial proceedings. The ability to communicate freely and confidentially with counsel is an inherent element of this right. This confidentiality means that communications between a detained person and counsel may be within sight, but not within hearing of authorities. Denying a suspect early access to counsel can endanger their rights, increasing the risk of torture or mistreatment. The right to a fair trial is a general principle that applies to the entire criminal process. It is more than the sum of individual enumerated rights, which are merely minimum guarantees. Fairness depends on the entire conduct of the trial. The most recognized pillar is the presumption of innocence, which dictates that all persons are presumed innocent until proved guilty according to law. The presumption of innocence is an absolute right that cannot be subject to restriction. Protecting this right requires that the burden of proof rests entirely on the prosecution to prove the guilt of the accused beyond a reasonable doubt. A provision imposing a reversal of the burden of proof is inconsistent with the presumption of innocence, as it allows for the possibility of conviction despite the existence of a reasonable doubt. Public officials, including judges, prosecutors, and government officials, must avoid making public statements prejudging the outcome of a trial prior to conviction. A fair trial is also characterized by a public hearing. The rationale for public proceedings is to allow public scrutiny of the judiciary and ensure transparency, safeguarding the rights of the accused. Although hearings must generally be public, exceptions may be made to protect morals, public order, national security, or the private lives of parties or witnesses, such as in cases of sexual offenses. Another pillar is the requirement for the trial to be held before a competent, independent, and impartial tribunal established by law. Impartiality, which means a lack of prejudice or bias, comprises both subjective and objective dimensions. The principle of independence is ensured through mechanisms for appointing judges and systems of privileges and immunities designed to protect them from state influence. Finally, the principle of equality of arms is implicit in the right to a fair trial. This means that the prosecution and the defense must be treated in a manner ensuring they have a procedurally equal position during the trial, allowing them to adequately present their case. Beyond the core pillars, several minimum guarantees govern the accused person's participation in the legal process. The accused must be informed promptly and in detail of the nature and cause of the charge, in a language they fully understand. International criminal law standards, particularly in the Rome Statute, broaden this scope by requiring information on the content of the charge as well. The accused must also have adequate time and facilities for the preparation of their defense. This is intrinsically linked to the concept of equality of arms. Facilities must include access to documents, records, and other evidence required to prepare the case, as well as the opportunity to engage and communicate with counsel. This necessitates disclosure obligations on the prosecutor, requiring the release of evidence that shows or tends to show the innocence of the accused, mitigates guilt, or affects the credibility of prosecution evidence. In some jurisdictions, the narrow interpretation of constitutional rights sometimes results in trial by ambush, where disclosure of evidence prior to trial is denied, contributing to delays and unfairness. The accused has the right to be tried without undue delay. This refers not only to the commencement of the trial, but also to the rendering of a final judgment and sentence. The determination of whether a delay is undue depends on factors such as the complexity of the case, the conduct of the accused, and the conduct of the authorities. The accused has the right to be tried in his presence. Proceedings conducted in absentia, without the accused's presence, are generally forbidden in Anglo-American systems and permissible only exceptionally for justified reasons under international human rights law, such as when the accused is disruptive or has fled, provided strict observance of defense rights is maintained. Finally, the accused has the right to examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. This right is integral to allowing the defense sufficient information to challenge a witness's reliability. However, this right may be balanced against the need to protect witnesses and victims, potentially necessitating proceedings in camera, or the presentation of evidence by electronic or special means. The accused is also entitled to the free assistance of a competent interpreter if they cannot understand or speak the language used in court. The right to appeal ensures that everyone convicted of a crime has the right to have their conviction and sentence reviewed by a higher tribunal according to law. This review must be substantive, examining both the sufficiency of the evidence and the law, and must be conducted without undue delay. The principle of ne bis in idem, or protection against double jeopardy, guarantees that no one shall be liable to be tried or punished again for an offense for which they have already been finally convicted or acquitted. The right to non-retroactivity of penal law confirms that no one shall be held guilty of any criminal offense on account of an act or omission that did not constitute a criminal offense under national or international law at the time it was committed. Furthermore, an individual cannot have a heavier penalty imposed than what was applicable at the time of the offense. Conversely, if, subsequent to the commission of the offense, a lighter penalty is provided by law, the offender shall benefit from it. In cases of a definite miscarriage of justice, where a conviction is reversed or a person is pardoned based on new or newly discovered facts, the individual who suffered punishment is entitled to compensation according to law, international criminal law, particularly through the establishment of modern tribunals like the International Criminal Court, ICC, has generally adopted standards of protection for the accused that meet or even exceed those set out in the UDHR and ICCPR. For instance, the ICC provides detailed provisions on the right to silence, ensuring that no reversal of the burden of proof is imposed. It also sets higher standards for counsel qualifications and comprehensive disclosure obligations on the prosecution. Modernizing the system involves leveraging technology and transparency. International tribunals ensure accessibility by making judgments, orders, and even full transcripts available online, and proceedings are often broadcast live, reinforcing the principle of public hearings. Furthermore, the ICC has adopted rules allowing the accused to request excusal from continuous presence at trial and appear through video link technology in certain circumstances, balancing the right to presence against logistical realities. Despite advancements, advocacy remains crucial to address persistent shortcomings, especially in national jurisdictions. Practices criticized as trial by ambush, the denial of pre-trial disclosure of prosecution evidence, still prevail in some subordinate court systems, undermining the core principle of equality of arms. The role of the judiciary is paramount in interpreting and enforcing these rights, as history has shown that unchecked power leads to abuse. The courts serve as the ultimate bulwark against unconstitutional legislation or administrative excesses. Enforcement of fundamental constitutional rights, such as the right to counsel and the right to remain silent, requires constant vigilance and judicial strength to ensure these safeguards are realized in substance, not just in form.